And good morning, WFYL listeners on 1180 AM. This is John Dancy, your host for It's a New Day. It's a beautiful August day. And today we are speaking with Mr. Jeff Clayton. He is the Executive Director of the American Bail Coalition. And I'm going to give you a little bit of background on Jeff. He spent 6 years in government service representing the Colorado State Courts and Probation Department, the Colorado Department of Labor and Employment, and the United States Secretary of Transportation. He's also a prior Presidential Management Fellow and finalist for the U.S. Supreme Court Fellows Program. Mr. Clayton holds a BBA from Baylor University, an MS from the University of Rochester, and a JD from the Stern College of Law, University of Denver. And Jeff, I'd like to welcome you this morning. How are you today?
I'm well. Thanks for having me on, John. I appreciate it.
Oh, yes, I appreciate you coming on today as well. Jeff, obviously, I was in law enforcement, retired trooper, bail. Someone gets arrested according to the severity of their crime, whether it's going to be an ROR or, surrender your passport. I think we all pretty much understand how that works to ensure that you are going to show up in court and have your day in court. What exactly is it now that has changed, and what is going on out there with the bail system in the United States?
Sure. So starting in about 2013, we saw a movement for what's called the no money bail system. In other words, we would simply lock somebody up, throw away the key, or we let them walk out on their own recognizance. And we've seen this movement really start in the federal system in the 80s and then kind of came to New Jersey first, and New Mexico was sort of the second state to go to it. What we've seen in the federal system is a tripling of pretrial incarceration over time, because when judges don't have the option to go to bail, they go to jail. And so bail on a case-by-case basis is important, not only for defendants' rights, but because the people that get released for free tend not to show up at the same rates as they would if they were on bail. And we all know why. It's because third parties, mom, dad, grandma, and the bail agent are putting pressure on the defendant to do what they're supposed to do. And so the new movement really has been about the no money bail system and completely throwing out the old system by changing state constitutions.
Okay. Obviously, the bail system, if you've got a lot of money or a smart lawyer, you pretty much got it made. But what about the folks that don't have access to that money or don't really have access to a bail bondsman? How's that working out?
Well, what we've seen is that the main issue is due process, that defendants don't know they have a right to ask for a bail reduction, and they don't. And a lot of times lawyers don't take it seriously. The other problem that we've seen is it's taken, in some cases, weeks to get in front of a judge to argue, your case for bail. And a lot of times judges will do a reduction. So I think due process has been the number one thing that we've seen that needs to be improved and that can kind of smooth over these problems. The other thing I think is, alternatives to bail are okay. If the person has a severe mental illness and that's really the risk, and there's mental health services available, then perhaps an OR bail with some services would be a better alternative. And so, that's really kind of the two areas that we look at that can kind of, diminish the problem as we see it. But, judges are looking at the severity of the crime. So it's not just finances that's the factor. There's a basket of factors that they look at.
Mm-hmm. Now, years ago, when someone was going to be, getting ready to post bail, or things like that, I believe, if I remember correctly, and I've been out of law enforcement for quite a while, but they would try to make an attempt to do a background investigation to find out exactly, what this person was all about, his ties to the community. And with this new algorithm system that I'm reading about, it's getting kind of scary, is the fact that the people are, the prosecutors are so understaffed that they can't go about doing these background checks anymore to find out whether someone is considered a flight risk. What's the story behind that?
Yeah, so what's going on is that there's pressure in the system because of resources to try to automate everything. And so the risk assessment was sold as a simple way to assess pretrial risk. The problem is the wheels have come off. 27 prominent academics, Harvard, UC Berkeley, Yale, et cetera, have said these things make the problem worse and they don't predict. 80 digital groups, Google, Facebook, Samsung, et cetera, have all said don't use them. 100 civil rights groups, ACLU, NAACP, et cetera, have said don't use these things. And so really what we've been saying for years is judges need the information, right? They need the criminal history information. They need exactly what you said. And so what we've successfully done in the last 5 years really 10 years is go into a movement where we're computerizing human judgment. And now I think the movement is to go back to the old way, which is, let's have human judgment and look into the statutory factors and present that information to a judge rather than simply giving him a score and say, well, he's a high risk, so hammer him.
Yeah, that seems kind of scary because they would have to think of every possible factor for every possible person that's been arrested. And I don't think it just doesn't seem possible at all. I mean, every case is obviously, as you know, very unique.
Yeah, I think so. And I think the other thing that we've seen is that, let's say, for example, you and I are both high risk category 5. Well, in New Jersey, for example, that's a 45% failure rate, which basically means one out of every 2 guys is a bad guy. The problem is we don't know if you're the bad guy or I'm the bad guy. We're going to tell the judge that you and I are both the bad guys. And that's where the science kind of breaks down, is we can put people into categories and we can put a percentage, but we can't pick the actual person who's going to do it versus the other person who's not. And that's kind of, to me, the fatal problem.
Okay. Now, what happened out in Missouri? Tell us a story about what happened in Missouri.
So we've seen over the last 5 years an attempt by Supreme Courts to simply skirt around the legislature and implement their own version of the no money bail system, which is essentially what the Missouri Supreme Court did. They created a presumption against bail, and then they put the algorithm risk assessment process as one of the drivers of the central process. They caught a lot of flack for it. They changed the rule a week before implementation, which turned out to be unconstitutional. And so the fixes to the rule are not in effect right now. And what we're seeing is a lot of repeat offenders getting out on free bails like we've seen in some of the other states. So this is a judiciary that is leading the bail reform movement. And talking to some of the legislators, they feel like the Supreme Court's out of their lane and they need to stick to judging and not, policy making from the bench. But that appears to be what's going on in Missouri.
Yeah. How close do you think that might be to being repealed? I mean, is the legislators going to step up and say enough of this?
They might. They very well, some of them that we were talking to are looking at it. The Constitution specifically provides that the legislature can overrule or modify a rule of the Supreme Court. And certainly the sheriffs, prosecutors, et cetera, have expressed their disdain for the rule. So I think we'll see some movement. The other thing in Missouri and I guess in other states that we've seen is typically there's some large blue ribbon panel that takes a look at it and does state by state changes that make sense. And in Missouri, the process was completely secret. We don't even know who was on the panel. But we do know that they met for several years, but we don't know who, we don't know what was discussed. And so where I see things going is more kind of toward a comprehensive study panel and look at Missouri to determine, what issues there are and what solutions there might be.
Now, Jeff, who made this algorithm, this risk assessment tool? Who made this up?
Well, it's really kind of existing corrections for, a generation. But the modern ones were really built by a guy named Edward Latessa, who built the Ohio tool upon which many are based, who's a professor at the University of Cincinnati. And then the other one was built by a guy by the name of John Arnold, who was a hedge fund manager, energy futures trader for Enron, who left Enron a mere, couple of weeks before the collapse and is kind of just a billionaire. His foundation built the most prominent one that's used throughout the country. But I can tell you right now, even he and his foundation are backing away from it and not pushing it as hard as they have in the past, and are actually supporting the transparency of it so that researchers can study, whether it's racially biased and its effectiveness, which is something that's desperately needed.
Okay. And you mentioned racially biased. I would obviously think from what I've read that it's pretty much biased against blacks. Has that been proven? Is there empirical evidence against that, or is that just something that we've all known all along?
Well, there has been in the case of the Compass tool, and really it was just back to the issue that we were talking about is you and I are both high risk. What that particular tool was doing was it was over-predicting African Americans as high risk and white defendants as lower risk, when in fact the opposite was true. And so that's been, the issue. I would say the jury's been out on it for several years, largely because the tools aren't transparent. We can't get the underlying data. We can't study them. But the 27 researchers that came out 2 weeks ago basically said they believe it is racially biased, largely because we take past historical data and we force the future to fit into those boxes. And to me, that makes sense. But I would say at this point, I still think the jury's out on, does it make it that much worse? Does it really make the system worse or not? But, certainly there's a lot of prominent people that think it does.
Okay. Are there any prosecutors that are just ignoring this and just saying, you know what, we're just going to do it the old way because it was more efficient and more fair? Is there a lot of pushback?
There is a lot of pushback, not just from prosecutors, but also from judges who say, hey, bail is an inherent constitutional right, and the legislature and court rules can do all they want, but at the end of the day, the Constitution governs. A major reform was passed in Colorado some 5 years ago to, push the risk assessment process, and what we've learned is that the judges largely ignored it. The same thing happened in Kentucky when the pretrial risk assessment tool from the Arnold Foundation was implemented. Was over time, the judges started by following it, but then over time they realized it didn't work and they stopped following it over a 3 to 4 year period. So judicial behavior is hard to change.
Okay. Let me ask you this risk assessment tool, do you have a number on how many factors this takes into account? Is it 5 factors, 10 factors, or is it more or less a whole page if you were going to fill it out by yourself? What are some of the questions that are asked here? Sure.
The Arnold Foundation tool is 9 factors. Most of them are not more than 12. Typically, the number one factor is age at first arrest, which has constitutional problems because you may not have been convicted of that. Prior crimes is always in there. Prior failures to appear is always in there. Substance use and mental health disorders are in there, although there's constitutional problems with that. And then, some use demographic factors, meaning like the Colorado tool. Do you own a home? Do you not? Do you have a cell phone? Do you not? Length of time in the community is a factor on some. So it just runs the gamut. And that, the amazing thing is that they can all be evidence-based and they can all have different factors. That's one thing I haven't been able to figure out is why in, New Mexico, this is a factor, but over the Colorado border, this is not a factor. We see that all across the country. Wow. So there's no real steady, 1, 2, 3 ABC thing. This is what it means. And that's the end of it. So that's interesting. Yeah. And I think, for my money, and having been in law enforcement, this, and, obviously I was in the law enforcement field myself for a while, is that history tends to repeat itself. And many bail agents know, were we to end recidivism, they would be out of business, which I think they would go for. But that's the reality is people who do it again, don't show up for court, and that's probably the best predictor. Mm-hmm. Yeah, it's amazing. If you're going to be putting money up or some sort of a bond and everything, and especially if your family is chipping in and putting their house up and everything, you better be showing up. It just affects not only the person arrested, but it affects everyone else around them if they've got a supportive family at least. Yeah, and I think once you burn your bridges, you've gotten yourself into a really bad spot because it's a third-party provided free benefit. And to have access to that is an amazing thing when you do. But when you don't, then that's when things, I think, start to go downhill. But, maybe that's what they should do because you're burning your own family at this point. Yeah. Are you seeing for minor crimes, are you seeing more ROR type releases for people who still have to post at least some sort of bail? I see some bails, like 10% cash, 10% bond. How does that work out? Well, these low-level theft cases, there's no bail, largely. There's roving bands of thieves going through neighborhoods in California stealing less than $1,000 at a time, going to stores. Heard stories in Ohio where gangs will go into a store, hit it. They will all steal less than $1,000 or the, felony threshold, and then return the merchandise at other stores, get gift cards, and then sell those on the street to buy drugs. And so another example that I gave was talking to a senator and had a case where the guy had 34 charges before he was convicted on the first one due to these OR policies. And the senator interrupted me and said, Jeff, you need to get the case with the guy with the 58 charges who, committed 57 additional crimes of theft before being convicted of the first. So that's the trend, is that we have no respect for retailers, brick and mortar retailers in this country any longer, which is unfortunate because that plays right into the Amazon internet era and hurts mom and pop brick and mortar shops in a lot of these small towns in the Midwest. Yeah. You know what I'm seeing? I've been in the security business for many, many years, and I'm seeing a lot of places just don't want to even bother prosecuting anymore. It's just not worth the hassle for smaller crimes, obviously, retail theft, things like that. And I understand in some stores, I think they don't even try to stop you anymore. No, they just sort of figure that's the, cost of doing business, and we'll just have insurance pay for it and then pass that along to the consumer. And but that's, I think, a lot of the reasons why brick and mortar stores are losing, because Amazon doesn't have that problem, right? They track everything, and obviously a few TVs fall off the delivery truck, but you don't have the consumer actually stealing from Amazon, which is, I think, the difference. So I think it's unfortunate. And, eventually we're going to say, well, we can just let that happen in felonies as well. And I think that's when we're really going to get into a problem. Oh, yeah. You get some of these people that are doing crazy things, and all of a sudden they're out and back around running on the streets, and that's just a little bit scary in itself. Folks, for your WFYL listeners, we are speaking with Jeff Clayton, the Executive Director of the American Bail Coalition.
and very interesting discussion today. Jeff, I wanted to ask you, there was a couple of talking points that I wanted to ask you about in regard to the secrecy of this whole thing. Why wasn't this put before the public? Because I know here in Pennsylvania, several years ago, there was a judge or two that went to jail because they were putting juveniles into these systems and they were getting kickbacks from it. And, it's a business. Let's face it, with these private prisons and everything that are being run now, it's a business. So, I guess the public doesn't have a say in this thing. Didn't want to put it before them. That's probably all intertwined, I would think, at some point.
Yeah, I think in Missouri, by way of example, a couple of the other places, really these justices are on a moral crusade. They think this is a moral crusade. And I can tell you it's not a moral crusade, that there is no new Camelot. It will not happen. And as we've seen in many places, it makes the system worse. And so while the current system people don't like, most people, the public, legislators, understand that when there's skin in the game, it makes a difference. And that's a simple message. But I think insulating themselves from scrutiny is the easiest way to get something done and keep it under the radar screen. And that's exactly what Missouri did. And so it worked. I think when you put things in front of the public and the legislators, it complicates things. And judges are bad lobbyists. And so that's, I think, why they do it.
Yeah. And obviously, let's discuss the costs to the Missouri taxpayers as far as these new rules. How's that all going to be taken care of?
Well, that's interesting. I think they need to give the New Jersey Association of Counties a call, who sued the state of New Jersey as a result of the new law and lost on a technicality that we thought they shouldn't have lost on. But, in New Jersey, it was $1 to $2 million a county to do the supervision and all the services that were required. In Missouri, because it's an edict of the Supreme Court, they're not getting any money. Mm-hmm. So when judges start ordering pretrial services because they can't impose a bail, somebody's going to have to pick up the tab for that. And we have no idea what that would cost in Missouri annually, but we got to think it's going to be similar to New Jersey, who's already spent, $200 to $300 million on this since implementation in 2017.
Jeff, let me talk a little bit about your background. How did you get involved with the American Bail Coalition? Is this something that you had been aware of for many years, or did someone come to you and say, hey, we need some new eyes on this. Let's get Jeff in here? How'd that work?
Yeah, so I had a law enforcement background defending police officers, and then I moved over to the state courts and probation. So I worked on bail reform as an issue and pretrial issues for, several years. I decided to strike out on my own law firm, my own lobbying firm, and got a call from the Colorado Association of Bail Agents, and they were one of my several clients that I represented for several years. And of course, the Bail Coalition did give me a call, liked the work we did on the 2013 reforms in Colorado and the 2014 reforms, and just said, we need a guy who's willing to travel and willing to learn and willing to be the spokesperson for this industry. And I thought it was a great opportunity to do some national work. And so took the job. Looking back on it, 15, 16, 17 were really hard years because of the amount of money spent on the left to try to take us out. But I think we weathered the storm, and things are starting to look up a little bit for a change.
Oh, that's good. And I noticed that why don't you just give the website? I was on that earlier today, and boy, what a comprehensive website that is. You could spend a lot of time learning there. Why don't you give that out and also give out a phone number while we have a few minutes left here? And if you
sure.
Would, so let the listeners know exactly where you're at and what you're all about.
Yeah, our website's ambailcoalition.org. The main office number is on there. Or you can call my cell phone, 303-885-5872. And we have my colleague, Chris Blaylock, to thank for the website. He does a tremendous job on all this stuff, of putting together all the information.
Oh, that's great. That's great. What do you see within the near future as far as possibly, getting rid of this risk assessment algorithm and getting back to what we would all probably consider normal?
It's going to take several years because there's still groups advocating for it, including the Pretrial Justice Institute, who was the main driver of this policy for 10 years, are still defending it, still advocating for it. So I think it'll take 2 to 3 years before jurisdictions finally say, enough is enough. This is a waste of money. Let's get everybody the criminal history and other information we need and move on. And, of course, on our website, we have the 4th generation of bail reform in America that talks about common sense reforms that we can look at jurisdiction by jurisdiction to improve the system without going to this expensive, nonsensical, algorithm-based no money bail system.
Yeah, it just doesn't seem like it takes into account a lot of other possible factors, and I wouldn't want to be judged by that, but evidently as we spoke about, with the advent of some of the social services and the mental health programs and things like that being so understaffed. In fact, I have a friend of mine who is a parole officer up in one of our northern counties, up in Northampton County, and they're just so overworked that, they don't have time to drink a cup of coffee and blink.
Yeah, and, when we're going to talk about spending millions, perhaps billions of dollars on pretrial services, the real game is post-conviction. Because these guys, once they're convicted, we can force them to go to treatment, and those are the issues. And that's where the money should be spent, not on some mythical reform that we can use a computer to, solve all of society's ills before somebody's convicted. That just doesn't make any sense.
Is there, with this risk assessment tool, is there any kind of tracking on who is actually using this and who isn't? In other words, if they say, well, 90% of the courts are not using this thing, we're just going to get rid of it. I mean, they can't force them to use this, correct?
Right, except in states where they're passing court rules to make them use it, or where the statute says they have to, like in Ohio. So there is no tracking of it. We don't know is the answer. We think, maybe a third of jurisdictions are looking at some version or using some version of it, but that's probably a rough guess. Most major metropolitan cities do have some version of the risk assessment, though. I would tell you that.
Okay. Is New York using this?
New York State is using it to a certain degree, but what's happened in New York was kind of an early pioneer, at least the civil rights groups there, told the governor for several years, and they had, I think, 200 civil rights groups in New York say, we hate this thing, don't use it. And so as a result, bail reform kind of went through and there were some changes made to the system, but the risk assessment process was never on the table in New York. Never has been, and I don't think ever will be.
Yeah. And what are they going to do if, like as you said in Ohio, they make you use it, and what's going to happen if can a judge decide not to and just say, you know what, sue me? How would that work?
Yeah, and largely it's just a factor, right? So they can ignore it. They have to take it into consideration, but they could immediately ignore it. And that's what we hear what they do in Ohio, is they pretty much, for the most part, ignore it, use it maybe as a tiebreaker. But I don't think many judges have much confidence in the Ohio tool.
Mm-hmm. Well, I think if they see that the old way has worked successfully, in spite of some of the, the offices and things being short-staffed and things like that. I mean, that's probably why there's so much of a backlog in the court system. We have to wait so long for hearings and court dates and things like that. But to err on the side of caution would probably be the most safe thing you could do at this point.
Yeah, I think so. And you do raise an important point about speedy trials is, in all bail reforms in history, speedy trial has been presented as the solution because it's bipartisan. It doesn't look at race. It doesn't look at anything. It just speeds up this little process that we have going. And if you're in jail less. If you're out of jail and on supervision, you're on supervision less. So the reality in this country is we just need to shrink the time frames to disposition, particularly on these misdemeanor charges. I mean, we can't have people sitting in jail for 90 days on a misdemeanor. That's just stupid.
Yeah. What about the outcry from the public defender's offices? Have they been vocal about this?
They have, and they've been on both sides of it. So, San Francisco public defender Jeff Adachi, who I think is was one of the only elected public defenders in the United States, was supporting the bail reform in California until it went off the rails and essentially, was this algorithm was the main driver of the process and went on to the other side. ACLUs around the country are starting to get on the other side against the algorithm, the ACLU of Ohio, the ACLU of Kansas, and others are likely to follow suit. And I think the public defenders will be right behind them saying, yeah, this doesn't help our clients. And what Adachi did, and I have to praise him for this, was he had specialist attorneys that were doing bail review hearings. And when somebody they thought had too high of a bail, they would go to hearing, and they were winning a third of the time. And that's what should happen. So I have to praise him for that. And I wish he was still around to continue that work.
Interesting. Well, we're just about out of time, Jeff. But, folks, we've been talking with Jeff Clayton, Executive Director of the American Bail Coalition. And, I'd like to get you on for an hour someday, Jeff, but unfortunately we're going to be out of time in a few minutes. But I did want to let folks know that if they want to go to the website of the American Bail Coalition, it is ambailcoalition.org. And they've got a wonderful website, a lot of information. And, Jeff, if you would give the phone number just one more time, I would appreciate it.
Sure. 303-885-5872 is my cell phone number if you want to call me directly. 303-885-5872. And also follow us on Facebook and Twitter.
Okay, that's great. Jeff, I want to thank you for coming on this morning. And as I said, we're just about out of time, but maybe we can get you back on for another half hour because there's just so much more to go through. But, folks, for the listeners on WFYL-1180 AM, once again, we've been speaking with Jeff Clayton, the Executive Director of the American Bail Coalition. Go to their website, find out about it. know what you're talking about, and maybe you can make some waves in the law enforcement industry, so to speak. So, Jeff, thank you very much. I hope you have a great day. And once again, this is John Dancy for It's a New Day, host on WFYL 1180 AM, working for your liberty. Thanks, Jeff.
Thank you.